wonderful.
London City, hello.
More women taking over the world.
Come on then.
Where to?
Home, I should think.
Which was the first country to commit to achieving net zero carbon emissions by 2050? Which country has the largest offshore wind capacity and will build 40 gigawatts of offshore wind power by 2030? Who has attracted a record number of offshore wind investments? Where can you find the world's largest wind farms and the first commercial floating wind farm? Which country is analysing the science of the wind and the seas? Designing and building the future of offshore wind. Where will you find a workforce with 20 years of industry experience? With operations and maintenance skills established on more than 40 operational wind farms. Who has hundreds of years of marine expertise? Which government is collaborating with industry and has a £1 billion net zero innovation portfolio to develop tomorrow's green energy solutions today? We're the UK, and we're ready to trade with you.
Fight against coronavirus is ongoing, and Britain's world-leading scientists are on the front line. The UK government, universities and pharmaceutical companies are standing together, working to find vaccines, treatments and tests, helping the world fight back against the virus. We've already made groundbreaking progress and will continue our leading role to save lives around the world, making vaccines and treatments available to all. The UK stands with the world, fighting coronavirus together.
wonderful.
London City, hello.
More women taking over the world.
Come on then.
Where to?
Home, I should think.
Pawan, good morning. How are you?
Very well, thank you. How are you?
I'm very well, thank you.
Enjoying London, I hope.
At least overcoming the jet lag. And on the way to the office, I saw London has.
Your Excellency, Ambassador Jenkins, how are you?
Selamat sore, Pak Damos. I'm very well, thank you. How are you? Very nice to see you again.
Very nice. Professor Akande, glad to have you here.
Pak Damos doesn't dare to
Good to see you too. Thank you very much for having me.
Right. We have a new ambassador in London now. So Professor Akande, you can give lecture as well to our ambassador. He's a scholar as well. Jenkins, thank you very much for the courtesy. So the event is look like well prepared now.
Not at all. I'm delighted to be here. It's this wonderful thing. Yeah, no, it's such an interesting issue. It's going to be here.
Desra, how's London now? How is in London the weather? Is it okay for you?
It doesn't matter about weather as long as in London it's beautiful always.
That's very diplomatic, Pak Desra.
Yeah, Pak Damos was just my neighbor in Padjadjaran in Kemlu, so I think we often tease each other. A very good morning, Professor Dapo Akande.
Good morning to you too.
Pleased to meet you. I'm the student of Pak Damos.
No, he's kidding. He was our neighbor, my neighbor here, but I miss him.
Good afternoon, ladies and gentlemen.
Okay.
Okay. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya. Good afternoon. We wish to welcome His Excellency Mr. Owen Jenkins, British Ambassador to Indonesia and Timor-Leste. His Excellency Dr. Desra Percaya, Ambassador, Extraordinary and Plenipotentiary of the Republic of Indonesia to the United Kingdom, Ireland, and IMO. The Honorable Dr. Iur Damos Dumoli Agusman, Director General for Legal Affairs and International Treaties, Indonesian Ministry of Foreign Affairs. The Honorable Professor Armida Salsia Ali Syabana, Professor of Economics at Universitas Padjadjaran, on leave since 2018, concurrently served as Under Secretary General of the United Nations and Executive Secretary of UNESCAPE based in Bangkok, Thailand, and the representative family of Professor Mohtar Kusuma Atmaja. The Honorable Professor An Chandra Wulan, Dean of Faculty of Law, Universitas Padjadjaran. The Honorable Professor Dapo Akande, Professor of Public International Law at Oxford Law Faculty. The Honorable Mr. Gusman Catur Siswandi, PhD, Director of Indonesian's Center for the Law of the Sea, Universitas Padjadjaran. The Honorable Mr. Haden Spicer, Political Counselor, Foreign and Security Policy Team, British Embassy, Jakarta, and of course to our honorable participants. It is a privilege and a great honor to be in the presence of this international webinar. My name is Ratih Mulia, and today I will be your master of ceremony for this event. Welcome to the international webinar on dispute settlement in the law of the sea, challenges and prospects. Ladies and gentlemen, please allow me first and foremost to inform you of today's program. The webinar will begin with welcoming remarks from our distinguished guests, and then will be followed by the plenary session, which will be chaired by our chairperson, Mr. Haden Spicer. We would like to extend our greatest appreciation to each and every one of you for being able to attend this international webinar. This event is a collaboration between Indonesian Center for the Law of the Sea, Faculty of Law, Universitas Padjadjaran, Ministry of Foreign Affairs of the Republic of Indonesia, and the British Embassy, Jakarta. Ladies and gentlemen, today's event is conducted as a part of the Nusantara Day or Hari Nusantara, which is commemorated every 13 December. This commemoration celebrates the history of Juanda Declaration or Deklarasi Juanda, which was proclaimed on 13 of December 1957. Deklarasi Juanda laid down the fundamentals of Indonesia as an archipelagic state. Ladies and gentlemen, in addition, today's event was conducted as pre-event of the second Mohtar Kusuma Atmaja Award conferral that will be held next year. The Mohtar Kusuma Atmaja Award was initiated by Universitas Padjadjaran in 2017 in cooperation with the Indonesian Ministry of Foreign Affairs of the Republic of Indonesia. The Mohtar Kusuma Atmaja Award is named after Professor Mohtar Kusuma Atmaja, an eminent professor at Universitas Padjadjaran. Ladies and gentlemen, now we are going to begin our first agenda, which is welcoming remarks. And the first welcoming remarks will be delivered by the British Ambassador to Indonesia and Timor-Leste. Let us welcome Mr. Owen Jenkins.
Thank you very much indeed, Master of Ceremonies, for that very kind introduction. And I'm delighted to be here today. Assalamualaikum, salam sejahtera, Om Swastiastu, Shalom, Namo Buddhaya, Salam Kebajikan. And let me add my welcome to all of you to today's webinar, which deals with the dispute settlement in the law of the sea. And as has already been pointed out, today's webinar has a distinctly international flavour, with participants joining us from across the United Kingdom, across Indonesia, and indeed beyond. And let me express my thanks in particular to Padjadjaran University's Faculty of Law, as well as to the Ministry of Foreign Affairs of the Republic of Indonesia for their cooperation and support in co-organising this exciting event. Let me particularly acknowledge and welcome some of our very distinguished speakers today. From the Ministry of Foreign Affairs of the Republic of Indonesia, I'm delighted to be able to welcome His Excellency Pak Damos Agusman, Director General of Legal Affairs and International Treaties, as one of our speakers today. His Excellency Pak Desra Pachaya, the Republic of Indonesia's Ambassador to the United Kingdom, and newly arrived in London. We're delighted to welcome him there. And also to Pak Bebeb Junjunan, Director of Legal Affairs and Territorial Treaties at the Ministry of Foreign Affairs. Let me also express thanks to Dr. Gusman Siswandi and Professor An Chandrawulan from Padjadjaran University, and in particular to Professor Armida Alisha Banya, as representative of the family of Pak Mohtar Kusuma Atmaja, for participating today. Before I hand over to our speakers, I have a few short remarks to make. As our Master of Ceremonies has already said, this event is also part of the celebrations for Hari Nusantara, Nusantara Day, commemorating the Juanda Declaration. And that declaration introduced the concept of the archipelagic state, which is now recognized under the United Nations Convention on the Law of the Sea. And the declaration and the introduction of that concept is a powerful reminder, I think, for all of us, of Indonesia's status as a pioneer of international maritime law and a strong protector of an international system based on agreed and commonly observed rules, particularly set out in international law. As has also been said, we are gathered today in the run-up to the 2021 Mohtar Kusuma Atmaja Award. Professor Kusuma Atmaja is a giant of Indonesian diplomacy. He spent 10 years as foreign minister of this great country and contributed hugely to the delineation of the country's modern borders. His scholarship in maritime and international affairs has been hugely international, both in Indonesia, but also internationally. And we are very honored to have this opportunity to celebrate his life and accomplishments in the presence of his daughter, Her Excellency Professor Armida Alisha Bana. Indonesia and the UK have developed a special, broad and deep friendship in our over 70 years now of diplomatic relations. we have many things in common. We are both diverse, multi-faith democracies, and perhaps more relevant to today's event, we are both archipelagic island nations. Indonesia has more than 17,000 islands, famously, but the British Isles have more than 6,000 islands. So both have many of the same challenges. And it's natural as a result of that we've developed very strong maritime and naval cooperation. There is a UK-Indonesia MOU on Navy and maritime affairs. We've created a joint course together on maritime security, and we have strong Navy-to-Navy cooperation with regular biannual talks, ships visits, and joint exercises. Indonesia and the UK are not only maritime nations, but we are nations that strongly support UNCLOS as a critical part of the international system based on rules and observed law. And UNCLOS sets out the legal framework within which all activities in the oceans and seas must be carried out. It sets a legal framework for maritime claims, as well as rules of freedom of navigation. It sets out obligations for bilateral, regional, and international cooperation, including for the conservation and management of living resources, for the protection and preservation of the marine environment, and for the peaceful settlement of disputes. UNCLOS is one of the biggest achievements of international law, and its preservation and observation are hugely important both to the UK and to Indonesia. How disputes under the law of the sea are arbitrated and settled is therefore crucial to the day-to-day diplomatic work of my country and of the Republic of Indonesia. And today's exchange of experience and ideas on that topic should greatly improve both of our countries' understanding of maritime law issues. We look forward to further dialogue on these subjects as well, ahead of the next instalment of the UK-Indonesia Partnership Forum, which is due to take place next year and is where we discuss our bilateral and foreign policy priorities, including the UK's ever greater commitment to the Indo-Pacific region. Before I close, just let me say a few words about our keynote speaker today from the UK, Professor Dapo Akande. Professor Akande is one of the leading scholars of international law in the United Kingdom. He has over 20 years of teaching and practice experience in international law. And as an international legal practitioner, Professor Akande has acted as a consultant to a number of international organizations, including the United Nations, the African Union, and the North Atlantic Treaty Organization. Among other things, Professor Akande has worked on international litigation before the International Tribunal for the Law of the Sea. And this combination of extensive academic but also practical experience is the reason why the UK has nominated Professor Akande as a candidate for election to the International Law Commission for the period 2023 to 2027, at the elections to be held during the 76th session of the UN General Assembly in November 2021. That depth of experience and knowledge is why I'm particularly grateful to Professor Akande for speaking to us today, particularly for joining us from Oxford at such an early hour in the morning. Thank you very much. I do hope that today's webinar will contribute to all of our understanding of the law of the sea and dispute settlement mechanisms within that. I look forward to the discussion, and I hope that it is productive and fruitful. Thank you.
Thank you, Mr. Owen Jenkins, for the welcoming remark. Ladies and gentlemen, we would like to apologize on behalf of the Dean of Faculty of Law Universitas Padjadjaran, Professor An Chandrawulan, as he is unable to attend this event due to the sudden loss of our head of bachelor study program. Nonetheless, Professor An sends her regards and gratitude to our partners today, the Ministry of Foreign Affairs of the Republic of Indonesia and the British Embassy Jakarta for their contribution in making this event happen. Ladies and gentlemen, the next welcoming remark will be delivered by Ambassador, Extraordinary and Plenipotentiary of the Republic of Indonesia to the United Kingdom, Ireland, and IMO. Please welcome Dr. Desra Percaya.
Thank you very much, MC. His Excellency Owen Jenkins, Her Excellency Professor Armida Ali Shahbana, my good friend, His Excellency, Dr. Iordamos Dumoli Agusman, DG for Legal Affairs and International Treaty, MOFA, my neighbor in Kemlu, a very strict legal-minded diplomat, and I'm also happy to share that he's a Hull University alumni. Professor Dapo, Akande, colleagues, ladies and gentlemen, a very good morning from London. Happy to see you all in good health. It is an honor for me to take part in this opening webinar. As the Indonesian Embassy is accredited to the IMO, the issue of orderly conduct at maritime domain is part of the Embassy's portfolio and responsibility. Although at the IMO itself, discussions are more on the technical implementation of maritime safety, the fundamental source of law of the instruments remains heavily on UNCLOS, as well as emerging issues related to the law of the sea, such as biodiversity beyond national jurisdiction, a form of the extension of marine environmental protection measures, combating IU fishing, including through safety of fishing vessels regulation. The law of the sea is widely regarded as one of the few international instruments with established dispute settlement mechanisms, whether through the means of the ITLOS, the ICJ, or arbitral tribunals as laid down by the convention. A high-profile case has been the South China Sea arbitration at the Permanent Court of Arbitration. The award in 2016 was a landmark ruling. This should provide plenty food for thought for this webinar, including how such a ruling has affected the dynamics in the South China Sea. Finally, I do have a humble request to and through Ambassador Jenkins for the UK government to allow more law professors to give lecture in Indonesia and increase their engagement both ways. I wish you all a fruitful and productive discussion, and I'm also happy to see my brother Pak Bebep here. Thank you very much.
Thank you, Dr. Desa Percaya, for the welcoming remark. Ladies and gentlemen, the last welcoming remark will be delivered by Professor Armida Salsia Ali Syahbana, the representative family of Professor Mohtar Kusuma Atmaja, and a professor of economics at Universitas Padjadjaran on leave since 2018. And Professor Armida concurrently served as Under Secretary General of the United Nations and Executive Secretary of UNESCAPE based in Bangkok, Thailand. The welcoming remark will be delivered via recorded video and will be followed by the video profile of the Mohtar Kusuma Atmaja Award.
Assalamualaikum warahmatullahi wabarakatuh. Ibu Dekan Profesor An Chandrawulan, Bapak Duta Besar Desra Percaya, Profesor Akande, distinguished panelists, ladies and gentlemen, selamat siang dan salam sejahtera bagi kita semua. Very good afternoon from Bangkok, Thailand. It is my honor and pleasure on behalf of the family of Bapak Mohtar Kusuma Atmaja to welcome you all to the international webinar on dispute settlement in the law of the sea, challenges and prospects. I would like to extend my sincerest appreciation and thanks to the co-hosts and co-organizers of the seminar, namely Faculty of Law, Universitas Padjadjaran, the Ministry of Foreign Affairs Indonesia, and the British Embassy in Jakarta for initiating the event. I welcome the webinar initiative as part of the Nusantara Day, December 13th commemoration event of the Juanda Declaration and as a pre-event of the second Mokhtar Kusumaatmaja Award to be conferred in 2021. The Mokhtar Kusumaatmaja Award was established by Universitas Padjadjaran in 2017 to recognize Pak Mokhtar's leadership and substantial contribution to the development of the archipelagic concept since the mid-1950s and until it becomes the archipelagic state principle under international law. The topic of today's webinar is one aspect on the implementation of the UN Convention on the Law of the Sea. Ocean and its resources are the lifeline of Indonesia and many countries in the Asia-Pacific region, home to two oceans, the Indian and Pacific Ocean. It is closely linked to the achievement of Agenda 2030 on Sustainable Development Goals and the Paris Climate Agreement. SDG 14, titled Life Below Water, on conserving and sustainably using the ocean, seas, and marine resources are an integral part of Agenda 2030 on SDGs. The UN Economic and Social Commission for Asia and the Pacific, or UNESCAP, in its SDG Progress Report for 2020, highlighted that the Asia-Pacific region needs greater acceleration in SDG 14 targets, where progress has been stagnant. Moreover, the overall state of the ocean health is fragile. Furthermore, the ESCAP SDG Progress Report also highlighted the lack of progress or even in the reverse direction on certain climate change SDG-related targets. The challenge for us then is how to promote synergy among the Sustainable Development Goals, in particular Goal 13 on climate action and Goal 14 on life below water. The synergy is urgently needed at all levels, national, regional, and global. The synergy is of utmost priority as it highlights the importance of ocean as an integral part of the Earth climate system. However, successful synergy could only be materialized through effective collaboration and partnership among the stakeholders, including contribution from academia. It is within this background, the philosophy of academic undertakings of Universitas Padjadjaran, established in 1972 when Pak Mokhtar was the rector, namely Pola Ilmiah Pokok, Bina Mulia Hukum dan Lingkungan, Hidup dalam Pembangunan Nasional, or to foster law and environment in national development, is highly relevant then and even as of today. I urge and looking forward to hearing more from you on the many initiatives on this front. I'm sure Pak Mokhtar will be delighted and full of support. Colleagues, ladies and gentlemen, I would like once again on behalf of the family to express our sincerest gratitude to Universitas Padjadjaran, Faculty of Law, the Ministry of Foreign Affairs Indonesia, and the British Embassy in Jakarta for this initiative. I wish you a very successful event. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
The Mokhtar Kusumaatmaja Award is named after Professor Mokhtar Kusumaatmaja, an eminent professor at Universitas Padjadjaran in Bandung, Indonesia. He was a former dean at the Faculty of Law and also a former rector of Universitas Padjadjaran. Professor Mokhtar Kusumaatmaja has also served as a Minister of Justice and as a Minister of Foreign Affairs of the Republic of Indonesia. He is widely recognized as a prominent Indonesian diplomat who has developed the archipelagic state concept and substantially fashioned it into becoming the archipelagic state principle under international law, and in particular the international law of the sea. Professor Mohtar Kusuma Atmaja also founded the philosophy of academic undertakings of Universitas Padjadjaran, namely to foster law and environment in national development. As an academician, the name of Professor Mohtar Kusuma Atmaja is preserved as the legal library building of Faculty of Law Universitas Padjadjaran, which was inaugurated in 2008. Professor Mohtar Kusuma Atmaja, as well as his invaluable contributions, the Rector of Universitas Padjadjaran, Professor Tri Hanggono Ahmad, has initiated the Mohtar Kusuma Atmaja Award.
Ladies and gentlemen, before we move to our next agenda, on behalf of the host, we would like to greet our viewers on YouTube. Thank you, ladies and gentlemen, for participating on today's webinar. Our next agenda is the plenary session, which will be discussing about current developments, challenges, and ways forward for dispute settlement in the law of the sea. And on today's discussion, we'll feature a prominent scholar from the university in the United Kingdom who is an expert in this field. And also, we are very pleased to welcome Mr. Haddon Spicer, Political Counselor, Foreign and Security Policy Team from British Embassy, Jakarta. And we are very honored to have Professor Dapo Akande from University of Oxford as the keynote speaker. And in this session, there will be two panelists, Dr. Iurdamos Dumoli Agusman, Director General for Legal Affairs and International Treaties, Indonesian Ministry of Foreign Affairs, and Mr. Gusman Catur Seswandi, PhD, as the Director of Indonesian Center for the Law of the Sea, Universitas Padjadjaran. Now, I would like to hand over the session to Mr. Haddon Spicer. Mr. Haddon Spicer, please, the screen is yours.
Hello, everybody. Sorry about that slight malfunction. So thank you everybody for those excellent opening remarks. Good afternoon to everybody. My name is Haddon Spicer. As has already been said, I'm the head of the Foreign and Security Policy Team at the British Embassy, Jakarta, and I will serve as your moderator this afternoon. As you know, this event is being held via Zoom and live streamed via YouTube. It is also being recorded as a podcast, which will be released soon after the webinar. If you would like to ask a question, please type in your question on the Zoom chat or in the YouTube live stream comment section. Please state your name and affiliation and to whom your question is addressed, and I will ask the question on your behalf during the Q&A session we might have a chance for actually direct questions from people. So if time permits and you want to ask a question directly, you'll be able to raise your hand and I will call on you. So now we're going to get to the most exciting bit of the event. It is now my pleasure to invite Professor Dapo Akande to give the keynote speech all the way from Oxford. The subject is Dispute Settlement Mechanism under the Law of the Sea Convention, Current Developments and the Way Forward. Professor, the floor is yours.
Thank you very much. It's a pleasure to join you today, to join all of you today for the commemoration of Nusantara Day. My thanks to our hosts for organizing this event and for inviting me to speak. Thank you to the Dean of the Law Faculty, Professor Chandra Wulan, and also to the representatives of the Indonesian Ministry of Foreign Affairs, particularly the Ambassador, His Excellency Dr. Pakaya, and also Dr. Aguzman, the Director General for Legal Affairs. And of course, my thanks also go to the British government, including those in the embassy in Jakarta, Ambassador Jenkins, Mr. Spicer, and those in the Foreign Office in London who have worked on this event. Our topic today is dispute settlement in the law of the sea, challenges and prospects. The United Nations Convention on the Law of the Sea, UNCLOS, was adopted on the 10th of December, 1982. So we are also just past the 38th anniversary of the adoption of one of the great international lawmaking treaties. That convention has often been described as a constitution for the oceans, and its adoption in 1982 and entry into force in 1994 were major achievements for the international community. The convention, or UNCLOS, as I will refer to it, sets out a comprehensive legal framework for activities in the oceans, which of course constitute the vast bulk of the world's surface. So much of the prosperity, security, and sustainability of our world depends on the oceans. They constitute the highway for international trade. Much of our energy needs and other natural resources come from the oceans. UNCLOS provides a legal framework for managing predictable and secure interstate relations in this area, and also for regulating the activities of private and other non-state actors. In addition to setting out substantive rules, which are just and comprehensive, the convention also constituted a major step forward for the principle that interstate disputes should be subject to compulsory third-party dispute settlement on the basis of law. Part 15 of the convention provides that if a dispute concerning the interpretation or application of the convention has not been settled by other peaceful means, and the parties have not agreed on another dispute settlement procedure, that dispute can be referred by any party to a court or a tribunal for binding dispute settlement. The provisions of the convention dealing with dispute settlement were, and they remain, rather innovative. Although it provides for the possibility for compulsory adjudication of most disputes arising under the treaty, UNCLOS does not impose a single forum for adjudication. Instead, the convention provides a range of options for dispute settlement, among which parties can choose by making a declaration. Parties may choose the International Tribunal for the Law of the Sea, based in Hamburg, the International Court of Justice in The Hague, arbitration under Annex 7 of the Convention, and special arbitration under Annex 8. Annex 7 arbitration is conducted in line with the typical rules and procedures for interstate arbitration, while special arbitration under Annex 8 provides for the selection of scientific and technical experts as arbitrators. And under that type of arbitration, the tribunal can carry out inquiries and undertake fact-finding functions in relation to disputes concerning fisheries, environmental protection, marine scientific research, and navigation. Now, it should be noted that states need not select a single forum. They can choose more than one, and if they wish, they can choose one forum for particular types of disputes and another forum for other types of disputes. So, for example, some states like Russia and some other ex-Soviet Union countries have chosen Annex 7 arbitration for most disputes, but have selected special arbitration under Annex 8 for disputes relating to fisheries, the protection and preservation of the marine environment, marine scientific research, and navigation. One of the special features of the convention is that if a party has not made a declaration selecting any particular forum for dispute settlement, then that state is deemed to have chosen Annex 7 arbitration. Indeed, most parties to UNCLOS have not chosen a particular forum, and I believe this is true also of Indonesia. And so in those cases, those parties will be deemed to have selected arbitration as their default mode of dispute settlement. And if two parties to a dispute have not chosen the same forum, so for example, one has chosen the International Court of Justice and another has chosen arbitration or ITLOS, then in such cases where the two parties have chosen different fora, Annex 7 arbitration applies as the default forum. Now, I should note that there are exceptions to the application of these compulsory mechanisms of dispute settlement. Some of these exceptions apply automatically. In other words, they are automatically excluded from compulsory dispute settlement. And so there's no obligation to have recourse to adjudication. So, for example, this will include disputes relating to marine scientific research and fisheries in the exclusive economic zone. Other exceptions are optional, meaning that a state may declare that it does not accept compulsory adjudication with respect to specific categories and limited categories of disputes. So disputes relating to military activities, disputes in respect of which the UN Security Council is exercising its functions, and most notably, maritime delimitation disputes. Now, in some contexts, where an automatic or an optional limitation prevents recourse to the usual mechanisms for legally binding compulsory dispute settlement, conciliation can be initiated by unilateral application of one party. And what's also notable about the dispute settlement system under the Convention is that states parties are not permitted to introduce any additional limitations to this compulsory dispute settlement system, for example, by way of reservation to the treaty. It is significant to note that UNCLOS and the related agreement on straddling fish stocks and highly migratory fish stocks are almost the only treaties deposited with the UN Secretary General since the 1960s, which both provide for compulsory adjudication or arbitration and also explicitly prohibit reservations, allowing parties to generally avoid this compulsory dispute settlement system. So what this means is that the Convention provides a much stronger system of compulsory dispute settlement than most other major multilateral treaties, which usually, at best, would explicitly allow states to make a reservation in order to avoid any exposure to compulsory dispute settlement. Now, part 15 of UNCLOS, this is the part that deals with dispute settlement. Actually, like the rest of the treaty, is the product of a series of complex negotiations requiring compromise between widely divergent viewpoints. The drafting history shows that states were divided on whether provisions for compulsory dispute settlement should be included in the Convention. Some states, mainly from the developing world, considered that accepting compulsory adjudication or arbitration would compromise their sovereignty. However, the great majority of states, including also from the developing world, considered that compulsory dispute settlement was an essential prerequisite for the effective functioning of UNCLOS. And various reasons were given by states for their insistence on compulsory dispute settlement. The fact that the text of UNCLOS reflects a series of delicate compromises was one such reason that was advanced for compulsory dispute settlement. Now, given the large number of parties to the convention, it is clear that a number of states that typically would opt out of compulsory dispute settlement in other treaties have been willing to accept compulsory dispute settlement in the context of the law of the sea. Many such states ratified the convention in the 1990s, a decade which perhaps in retrospect appears to have been a high point for multilateralism. The willingness of these states seems to confirm that the most effective way to get states to consent to compulsory dispute settlement mechanisms is to incorporate those mechanisms as an inherent part of a substantive treaty, which is seen as bringing real benefits to the parties. So I said that under UNCLOS, parties can choose one of four mechanisms for having recourse to adjudication of their disputes. Let's have a look at what parties have actually done since the convention came into force. About 50 states, parties to UNCLOS, have made declarations selecting a particular forum or fora. Now, the relatively low proportion, it's 50 out of 168 have made these declarations. But the relatively low proportion of parties which have made these declarations may be considered surprising, given the importance which states appeared to accord to the issue of forum choice during the drafting of UNCLOS. One commentator has suggested that in many cases, the failure to make a declaration may simply be due to bureaucratic inertia in national governments. And this is in line with research that shows that treaty parties generally tend to accept the default position regarding dispute settlement rather than utilize opt-out or opt-in clauses. However, in the context of the Convention on the Law of the Sea, this seemingly low number of declarations may actually reflect a conscious preference for Annex 7 arbitration, which applies as the default mechanism. Arbitration seems to be preferred to judicial settlement by many states, since it allows them to retain a greater degree of control over the dispute settlement process. It is interesting to analyze the choices that states have made when choosing their preferred forum for dispute settlement under UNCLOS. Of the 50 states that have made a choice, 22 states have chosen the International Tribunal for the Law of the Sea, ITLOS, as their sole first preference. 6 states have chosen the International Court of Justice as their sole first preference. And 12 have chosen both ITLOS and the ICJ without ranking them. All in all, 37 states choose ITLOS either solely or their equal first choice. 20 choose the International Court of Justice, and 8 choose Annex 7 arbitration, with 6 choosing special arbitration under Annex 8. So ITLOS seems to be the more popular option, more popular than the International Court of Justice, though not by an overwhelming margin. This in part reflects continued support from developing states, which championed the formation of ITLOS during the negotiation of UNCLOS. But it's significant to note that a number of developed states have also chosen ITLOS as their preferred mechanism for dispute settlement under the law of the sea, suggesting that the fears among such states at the time of the drafting of UNCLOS that this new tribunal could radically unsettle the law of the sea have largely vanished. Few states have provided public explanations for why they have chosen a particular mechanism. One exception can be found perhaps in the statement made by the Australian government legal advisors before a parliamentary committee. The Australian Attorney General advised the committee that Australia had waited some time to see how ITLOS would function in practice before making a declaration. And once it gained experience of ITLOS by appearing before it, Australia selected ITLOS along with the ICJ, with which Australia had already had extensive experience. And the cost advantages to parties of standing courts over arbitral tribunals were emphasized. As I indicated earlier, arbitration has been chosen by a few states, but since relatively few states have made a declaration choosing any mechanism at all, arbitration actually remains the default option, and so the great majority of UNCLOS cases have been initiated under Annex 7 arbitration. There have been 24 cases brought under ITLOS, excluding a few cases dealing with prompt release of vessels. And of those 24, 21 have commenced as Annex 7 arbitrations, 3 as ITLOS cases, and however, 5 of those Annex 7 cases were subsequently transferred by agreement to ITLOS, to the International Tribunal for the Law of the Sea, probably for reasons of cost. And significantly, no law of the sea case arising under the convention has been decided yet by the International Court of Justice. However, as I will discuss later, the case law of the International Court of Justice establishes that jurisdiction under the optional clause of the ICJ statute will preempt jurisdiction under the convention. One significant challenge that has arisen with respect to dispute settlement in the law of the sea relates to how tribunals faced with such disputes are to separate matters subject to their jurisdiction from matters that are not subject to their jurisdiction. These tribunals only have jurisdiction over disputes arising under the convention, under UNCLOS. However, it is often the case that disputes relating to maritime entitlements are intimately linked to disputes relating to territorial sovereignty. Thus, it is often the case that maritime disputes cannot be decided without also determining as a preliminary question which state has sovereignty over the relevant territory. Indeed, very often, UNCLOS ascribes rights to, quote, the coastal state. And to be able to determine which state has relevant rights in the law of the sea, one will frequently need to find out which state is the coastal state. So disputes about rights and obligations in a maritime zone will concern UNCLOS, but a dispute about territorial sovereignty is not determined by reference to UNCLOS. Rather, such disputes are governed by other fields of international law, most notably the law relating to acquisition of territory. In order to argue that an UNCLOS dispute, which also raises issues of territorial sovereignty, falls within the jurisdiction of a tribunal established under UNCLOS, it has been argued that UNCLOS tribunals have what has been described as incidental jurisdiction to deal with the territorial sovereignty dispute at issue. Now, this problem of mixed disputes involving territorial sovereignty issues, as well as law of the sea, has played an important role in a number of recent cases. For example, the case between Mauritius and the United Kingdom, arising out of a dispute relating to the Chagos Islands. The dispute, which has already been referred to today, between the Philippines and China in relation to the South China Seas, also raised this problem of mixed disputes. And most recently, this problem of mixed disputes arose in the context of an arbitration between Ukraine and Russia, which raised questions as to sovereignty over Crimea, which is occupied by Russia. The arbitral tribunals in all three of these cases, Mauritius, UK, Philippines, China, Ukraine, Russia, were consistent in holding that they lacked jurisdiction over claims that implicated a territorial sovereignty dispute. However, the reasoning in these cases is slightly different. Let me take the Ukraine-Russia case, decided actually just earlier this year. So Ukraine brought a dispute before an UNCLOS arbitral tribunal and argued that the tribunal had incidental jurisdiction to address the question of which state has title over Crimea, which has been under Russian occupation for about 6 years. Ukraine argued that the law of the sea dispute, Ukraine argued that the dispute relating to Crimea was neither the real dispute in the case, and also argued that the relative weight of the dispute between it and Russia lay elsewhere. In other words, it argued that the real dispute was a law of the sea dispute. And it said that the territorial sovereignty issue was not actually the real dispute. However, the arbitral tribunal in that case followed the approach taken in Mauritius versus the United Kingdom and held that where you have a minor issue of territorial sovereignty, which can be characterized as merely ancillary, for example, in the context of a maritime delimitation dispute, such a minor issue of territorial sovereignty could potentially be within the jurisdiction of the UNCLOS tribunal. However, in Mauritius, UK, in the South China Seas arbitration, and in Ukraine, Russia, the sovereignty question was a prerequisite for several of the claims, including the claims by Ukraine, and the tribunal held that that sovereignty question or those sovereignty questions were not merely ancillary. So the approach that was taken in the Ukraine-Russia case, or rather the outcome of the Ukraine-Russia case, was in line with the approach that was taken in Mauritius versus the United Kingdom. However, neither of these cases clarifies the scope of what is an ancillary sovereignty dispute, nor tells us how to decide where the real weight of the dispute falls. So the arbitral tribunals found, or in the Ukraine case in particular, found that it did not have jurisdiction over those claims of Ukraine that required a decision of the sovereignty dispute. As this affected many of Ukraine's claims, the arbitral tribunal requested Ukraine to file a revised version of its memorial that reflects the tribunal's findings on the extent and the limit of its jurisdiction. In a recent case between Mauritius and the Maldives, the International Tribunal for the Law of the Sea will likely for the first time also face an objection in the context of a maritime delimitation dispute, an objection that argues that it is not competent to adjudicate on a related territorial dispute. Both the United Kingdom and Mauritius claim sovereignty over the Chagos Archipelago, which is located in the proximity of the Maldives. And Mauritius has brought a maritime delimitation claim against the Maldives, arguing that it, Mauritius, is the coastal state, and so seeking to use this maritime delimitation dispute as a means of obtaining a decision by ITLOS that it is Mauritius, not the UK, that has sovereignty over the Chagos Islands. It remains to be seen what the ITLOS will decide, but the approach that was taken by the arbitral tribunal in Ukraine versus Russia might be relevant for ITLOS. In other words, looking at whether or not the territorial dispute is an ancillary, is merely ancillary, and looking at whether or not the relative weight of the dispute actually falls with regard to the territorial sovereignty, or rather with regard to the law of the sea issue. And so we will see how this issue develops, but it's quite likely that this is an issue that will come before UNCLOS courts and tribunals repeatedly. And this is because there is compulsory jurisdiction for disputes under UNCLOS, but of course, no compulsory jurisdiction in relation to territorial disputes, except in cases where the parties have otherwise consented to the jurisdiction of a tribunal. Now let's look at the relationship between the jurisdiction that is provided for under UNCLOS and the statute of the International Court of Justice, particularly the compulsory dispute settlement clause under the ICJ statute. Under the optional clause of the ICJ statute, the International Court potentially has jurisdiction over all disputes concerning international law for those states that have accepted such jurisdiction. And of course, this includes jurisdiction involving the interpretation and the application of UNCLOS. The relationship between these two bases for jurisdiction is of great importance for disputes between parties to UNCLOS, which have also made optional clause declarations. So where a state is a party to UNCLOS, but has also at the same time accepted the compulsory jurisdiction of the ICJ, the question arises as to which of these mechanisms actually, which of these mechanisms is to be regarded as providing the answer as to which tribunal the dispute goes. In a recent judgment in a maritime delimitation case between Somalia and Kenya, the International Court of Justice clarified the relationship between its jurisdiction under the optional clause and the compulsory jurisdiction provisions under UNCLOS. Somalia brought a maritime delimitation case against Kenya in the ICJ, relying on both states' optional clause declarations under the ICJ statute. Kenya sought to rely on the reservation in its declaration, that's its UNCLOS declaration, in its optional clause declaration, excluding disputes where the parties had agreed on another method of dispute settlement. Kenya argued that UNCLOS constituted such an agreement and therefore the ICJ did not have jurisdiction. The International Court rejected Kenya's argument and found that it had jurisdiction under the optional clause of its statute. It referred to the provision of UNCLOS, which provides that the parties to the convention may agree through a general, regional, or bilateral agreement or otherwise to submit a dispute to a procedure entailing a binding result, in which case that procedure applies in lieu of the procedures in UNCLOS. And the court decided that the phrase "or otherwise" encompassed an agreement to the jurisdiction of the ICJ resulting from the optional clause declarations. The court then interpreted Kenya's reservation concerning other agreed means of peaceful dispute settlement and found that that reservation did not apply. So the International Court's decision that an optional clause reservation referring to other agreed methods of dispute settlement does not apply to UNCLOS has resolved what was previously a difficult question. Both Kenya's optional clause declaration and the United Nations Convention on the Law of the Sea, on their terms, appeared to give precedence to the other agreed method of dispute settlement. And it wasn't quite clear when you have two instruments that appeared to give precedence to the other method, it wasn't quite clear which would take precedence. But the ICJ's decision breaks that sort of circular reasoning and makes it clear that in such a case, it is the international court's jurisdiction that will take precedence. So let me now turn to some conclusions. The picture in relation to interstate dispute settlement in relation to the law of the sea has been mixed. We've seen a gradual upward trend, for example, in the number of declarations that have been submitted, a number of declarations made under UNCLOS. We have seen an increased number of cases being submitted to compulsory dispute settlement under UNCLOS. There has been an initial preference for Annex 7 arbitration, but states having initially gone to Annex 7 arbitration, states have also increasingly then decided to transfer these cases to the International Tribunal for the Law of the Sea. States seem to have found confidence in the jurisdiction of the International Tribunal for the Law of the Sea. And as the caseload of that tribunal has increased, more and more states have been willing to take their disputes to Hamburg, take advantage of probably the reduced costs of going to a standing international tribunal, as opposed to establishing arbitration from scratch. A difficult issue that remains in relation to dispute settlement under the law of the sea is the question of how to separate out law of the sea disputes in relation to which there's compulsory dispute settlement from those disputes that are related to the law of the sea, but which do not fall within the jurisdiction of tribunals under UNCLOS. So let me stop there and turn over to the other participants in this webinar. Thank you very much for your time.
Thank you very much, Professor Akande. I was struck by the number of different options there are for dispute settlements. You know, it covers the fishing disputes, territorial disputes, and also I was a little bit surprised about the numbers of people actually taking up and following through on a number of these disputes. So I'm sure we can discuss that a little bit further later, why you think that is, and what we can do to try and encourage more people using this dispute mechanism. I think that was fascinating. And I think you said, thank you so much for setting out so clearly. So I think we can now move on to the next phase of the discussion. And also I want to remind people as well, the audience, that questions can be asked via the chat facilities on Zoom and on YouTube, and we'll pick them up during the Q&A session. So before we go on, thank you so much, Professor Akande, for that presentation. And now we move on to two panelists who will be presenting specific aspects of today's topic. Our first presenter is Dr. Damos Dumoli Agusman, currently Director General of Legal Affairs and International Treaties at the Ministry of Foreign Affairs of the Republic of Indonesia. Prior to his current role, Dr. Damos has held a number of prestigious diplomatic positions overseas, such as Indonesia's Consul General in Frankfurt. Dr. Damos is also an alumni of Padjadjaran University and has studied in the UK and Germany. Today, Dr. Damos will be presenting on Indonesia's experience in international dispute settlement. Dr. Damos, the floor is yours.
Thank you very much, Mr. Spicer. Your Excellency, Ambassador Jenkins, and also ladies and gentlemen. And this is a great honor to me to share the Indonesian experience, especially how Indonesia dealing with UNCLOS mechanism. And I'm very glad that this webinar will be able to have a very good exchange of views among scholars. And I'm here, of course, representing the government rather than academic community. Dr. Guzman will take that role. So I would like to request if the organizer can share screen to me to give access, because my English pronunciation is not very good. So I like to being helped with the some slide that I would like to show to you. Right. First of all, because this is the time of commemorating what so-called Professor Kusuma Maja contribution to the law of the sea, and I would like to share with you what actually Professor Kusuma Atmaja contribution to Indonesian in relation to its compliance to international law. So Indonesia before independence is like this map. So there is a high seas in between, and then Deklarasi Juanda, the Prime Minister Juanda at that time declared unilaterally closing the waters by connecting the outmost island, and then declared that the waters enclosed was internal waters. Of course, this is a political move. And what happened at that time, I would rather say, from the international law perspective, this is unilateral act, and many said that Indonesia was breaking international law. So Indonesia was not comfortable with the label of the breaker of international law. Now Indonesia did a lot of things at that time, and Professor Kusuma Atmaja was one of the figure, one of the international lawyer of Indonesia that tried to fix this problem. Right now, we then tried to go to UNCLOS conference and then make negotiations. And then after that, finally, it is agreed in UNCLOS 1982. And what happened next? Next, Indonesia is considered to be making instead of breaking international law. So this is the contributions, if I may say, how my constructions to the contributions of Professor Kusuma Atmaja in dealing with this. So then what Indonesia actually did at that time? The first, and I think the foremost effort is diplomatic effort. And then Professor Kusuma Atmaja came into this fore. What Professor Kusuma Atmaja actually did at the time in the first stage is transformation of Juanda declarations, because Juanda declaration is a political declaration, and then Professor Kusuma Atmaja translated into a legal concept that was eventually known to international law. So what Professor Kusuma Atmaja tried to do was to provide the concept in the language of international law. So in order to make easy for the international lawyer at the time to understand what the concept was actually about. And this is what Professor Kusuma Atmaja did at the time. And then after that, it is not enough, because again, then Professor Hasim Jalal, the diplomat, our very talented diplomat, tried to bring the concept, bring the text to the negotiating table, and then fighting for international recognition, of course, through diplomatic mechanism. And there's a package deal, quid pro quo, and Professor Akande already mentioned that this is a very complex negotiations. So at the end, we achieved what so-called archipelagic concept. So that's what Professor Kusuma Atmaja trying to do. Right, in relation to the dispute settlement that we are now discussing, this is the first point that I would like to mention, that Indonesia, not only starting from dispute, but Indonesia started from breaking the law. So breaking the law, and then we find the solution, and then we find dispute resolutions on the what so-called breaking the law. And we are so proud that in Indonesia now being called as making international law instead of breaking it. Right. Now I come to the type of law of the sea related dispute in the regions, because Indonesia neighboring 10 countries, and also we are surrounded by many coastal states. So Indonesia is also see the potential dispute that might arise in the region is the first is on the title to maritime feature. Indonesia was lucky, and now Indonesia already settling the dispute on Sipadan and Ligitan, but of course other neighbor still have that kind of dispute. South China Sea dispute is one of the example of this kind of dispute. And then the second type of dispute that might arise is about the maritime delimitations. Indonesia is now doing maritime delimitations with 10 neighbor country, and we still doing that and still ongoing, because a lot of things to negotiate it on the maritime delimitations. But one of the most potential dispute that might arise is about the legal enforcement in the undelimited waters, because Indonesia also bordering undelimited waters, EEZ overlapping claim, for example, continental sub overlapping claim, and we have also territorial sea overlapping in Malacca Strait and State of Singapore, and we have also territorial sea undelimited with Timor-Leste. The next potential dispute is about activities in EEZ or continental shelf that might happen also in the vicinity of Indonesian waters, and of course there is also other things that might arise in the region. And I would like to maybe to share with you about how ASEAN way or regional attitude when dealing with the dispute settlement in the regions. We rather try to put aside differences and goes to cooperations rather than go to third party. So that's the first maybe the ASEAN way, how ASEAN way try to see the dispute. And then sometimes many states saying that, oh, let the next generations settle the dispute, at least not in my time. I mean, they are not willing to be busy on dealing with the complex issue, especially on the dispute on maritime issue. And then try to tone down the dispute, if I may say, to put under carpet, and then try to do the cooperation rather than talking about the dispute. And of course, this is also the preferable approach on the procedure. They like more voluntary over compulsory. Yeah. They like to be consent rather than to be compulsory condition. Now, so that means that in the ASEAN way, negotiation is preferable to third-party settlement of dispute. And this is also the common trend that Indonesia also look like sharing this view. Yeah, the more technical the dispute will be, the more we like to go to the third party. So Indonesia is now having many cases in the WTO, also in the arbitrations on the dispute on the trade investment, for example. So we get used to to be in the third-party litigations. But on the sovereignty and on the political issue, especially on maritime issue, Indonesia prefer to have a direct negotiation rather than go to the third-party dispute settlement. So perhaps Indonesia is also looking forward to have a kind of good office and also conciliations and mediations before we jump to the what so-called third-party litigation. Now, UNCLOS already set up, already provide jurisdictions, and Professor Akande already make it very clear on this about what so-called Article 298 exceptions. The parties may declare so to put to or to reserve that the historic base, the dispute on historic base or title, dispute on maritime delimitation, and dispute on military activities to be exempted from the compulsory procedure. And Indonesia does not make this kind of exception. But look at this. This is a trend in the regions, at least in the Indonesia neighbor. Australia already declared the exception. South Korea, China, Thailand, Singapore, and Malaysia. And then I put question, who next? And of course, Indonesia is not considering to follow these exception declarations. But I don't know, the next generations perhaps will thinking otherwise, or I don't know, whether Dr. Guzman has also from the academic community how to deal with this kind of option. But Indonesia is still committed to the UNCLOS provision as the whole without making any declarations or exceptions on this in this regard. Right, but if I may say, the Indonesia DNA, I borrow the medical term, the DNA. Indonesia DNA actually always against compulsory dispute settlement mechanism. So I can also share with you that Indonesia, and Professor Akande put it right, that we have no declarations on the ICJ compulsory jurisdictions under Article 36, Para 2 on the ICJ statute. So we have no declarations, right? And then on the Human Rights Treaty, for example, we make reservation when the clause saying that dispute shall be referred to ICJ, we make reservations on this article. So, for example, on the conventions of CIRRD, CEDAW, and also CAT, for example. So, since 1980s, we always make reservations when the conventions provide compulsory jurisdictions to the ICJ. But this is a very interesting, if I may say, was before. We have a treaty with Thailand in 1954, and then we have also the treaty with the Philippines. That's a treaty of friendship. This is a very old-fashioned treaty, and in this treaty, we do have optional clause that dispute which is not settled through negotiation shall be referred to ICJ. So this is, if I may say, a kind of exceptional situations on the general directions of Indonesia attitude on the compulsory jurisdictions. But Indonesia, of course, does not make any declaration to Article 298 UNCLOS. So that's mean Indonesia will be open for dispute settlement under Annex 7 of UNCLOS, because we we do not choose any mechanism. So Professor Akande already mentioned. So that's mean Indonesia deemed to accept arbitral tribunal under Annex 7. Right. Now I'd like to also to share briefly about Sipadan and Ligitan case. Why we went to ICJ, because this is also a very exceptional case that Indonesia used to third-party dispute settlement. Yeah. So the case started in 1969. At the time, we had negotiation on continental shelf, and then the two islands, Sipadan and Ligitan, were founded as a disputed, and then we have negotiations. So this is a very important point. We start with negotiations, and then the negotiations went in the very long period, since 1988 until 1996. So it's almost 10 years, uninterrupted negotiations. So we start from the technical official, and then when the technical official level exhausted, we went up to the senior official, and then it was also exhausted. There is no solutions. And then we further up, went to the Minister of Foreign Affairs level, and it was also failed. And then further up to special envoy. So this is a kind of hierarchy mechanism that we did, and this is a very good example how Indonesia pursued the case step by step level. And through the special envoy, at the end we decided to go to the ICJ, and then ICJ make the decisions, and Indonesia accept the decisions of ICJ. So that means Indonesia is not unfamiliar with the third-party litigations. Indonesia is very friendly to the third-party litigations, even on the issue of sovereignty issue. Right, so a lot of discussions among politicians at the time, why we went to ICJ. And some say that this is about domestic interests, yeah, or what so-called domestic saving face formula. But I would like to emphasize here that President Suharto at that time made a very good remark. He said that the government doesn't like to put the burden to the next generation of Indonesia. And we are very happy with that remarks, because now Indonesia has no longer any island dispute or any title to territory that can burden the next generation. Right, choice of mechanism, I think the first is, perhaps I would be honest, that dispute over title to territory or sovereignty most unlikely solved through bilateral negotiations. The reason is very simple, because when we are talking about sovereignty issue, we always start from absolutist position. That means no negotiation on sovereignty. Yeah, in Indonesia we have a very strong remarks. Yeah, we call it NKRI harga mati. Yeah. NKRI harga mati means that there is no negotiations on sovereignty. And then, but negotiations at this stage is best to exchange and clarify the claim. So this is also the reasons why Indonesia always promote the claimant state in the South China Sea to negotiate. At least they can exchange and clarify their claim, because this is a very good start before we go further into the next step of the dispute settlement. Right, so there's a dilemma, at least facing the government. The dilemma, the first is the impossibility of negotiations, because it is impossible to negotiate sovereign issue. And then versus prohibition of use of force, because states now are not allowed to use of force in settling the dispute. And then versus reluctant to engage third party. So this is the dilemma, not only facing Indonesia, but also facing our neighbor, yeah, ASEAN country. So the dilemma is there. So we need, of course, to remove this dilemma by public educations, by what so-called more international law socializations, so public can be aware about what internationally is about and what the dispute settlement is all about. Right, but the trend model now, if I may say, the first is try to keep it unresolved. So again, state in the regions try to put it under carpet and try to say let the next generations will deal with that. But if there is no choice, then we go to the joint development. Yeah, of course, this is also a very complicated one, but at least we did it with Australia at the time when the dispute cannot be settled. So if the joint development is not satisfied, then we go to negotiations, conciliations, and mediations before we come to the what so-called third-party settlement of dispute. So the third-party settlement of dispute is still exceptional option rather than primary option. So for example, Indonesia now negotiating with the neighbors, and then we still have a lot of pending. But I would rather to say that Indonesia is the busy state that very busy in boundaries negotiations. So sometimes we have 9 documents with 9 states on the negotiating table at the same time. So Mr. Bebep, our director, is very busy in doing this. So this is again negotiation is we put emphasis on the negotiations rather than suddenly go to the third-party dispute settlement. Right. To conclude my presentations, I would like to have to make observation rather than conclusion. First is Indonesia compliant to UNCLOS is a full compliance. So that means it includes full compliance to its dispute settlement. So Indonesia is still, Indonesia is still within the dispute settlement of UNCLOS. There is no exceptions that Indonesia declared for the time being. But the second point is model of negotiation is still prevailing. Indonesia is a dialogue-loving country. We like dialogue. We like to talk rather than to be a quarrel. And then my third observation is resort to use of force, of course, is not option. It has been obsolete from the Indonesian political agenda. So that's all my presentations. Thank you very much. I hope this can help to enrich the discussions. Thank you, Mr. Spicer.
Thank you very much. That was really helpful. Lots of really good insights there. I was particularly taken by your ASEAN way description and how you went through that. And it'd be interesting as well to explore how that will feed into the negotiations with the Code of Conduct in the South China Sea, how the ASEAN way will be able to maneuver into the Code of Conduct negotiations. It'll be fascinating to see that goes on, and perhaps something we can talk about in the future. So thank you so much for that. That was really, really helpful, very interesting. I think we can now move on to our final presenter, who is Dr. Guzman Siswande. Dr. Guzman is the director of the Indonesian Center for the Law of the Seas and the Vice Dean of the Faculty of the Law at Padjadjaran University. Dr. Guzman is also an alumni of Padjadjaran University and studied overseas in the UK and Australia. Dr. Guzman has also worked with the government of Indonesia on the Biodiversity Convention, the Cartagena Protocol, and Nagoya Protocol. Today, he will be presenting on marine environmental protection and the role of the International Tribunal for the Law of the Seas. Just before Dr. Guzman starts, I just want to give apologies from my ambassador who has had to dash off to another meeting, but he really enjoyed the presentations he was here for, and he looks forward to following up in the future. So Dr. Guzman, the floor is yours. Thank you very much.
Thank you very much, Mr. Hayden Spicer, for the kind introduction. Assalamualaikum warahmatullahi wabarakatuh. A very good morning and good afternoon to all of you. On behalf of the faculty, I would like to take this opportunity first to thank our co-organizers for this webinar, the British Embassy and also the Ministry of Foreign Affairs of the Republic of Indonesia, and also my dear colleagues at the Faculty of Law, Universitas Padjadjaran. It is such an honor to share this panel with these distinguished speakers, Professor Dapo Akande, and also Dr. Damos Agusman. It is such a privilege. And also our apologies that the Dean could not deliver her welcoming remarks earlier. We are still actually in mourning today for the untimely passing of one of our colleagues at the faculty, Mr. Abi Rajab. He's the head of the undergraduate of the Faculty of Law. So we have just conducted his funeral earlier this morning. May he rest in peace, and our prayers go out to his family. Thank you also to all the participants for joining this webinar. And my focus on the today's webinar is actually on the marine environment and how the International Tribunal for the Law of the Sea has its role in implementing these protection of preservation of the marine environment under the Law of the Sea Convention. I'd like to share my screen, but fortunately this host has disabled the screen sharing. So if I can ask for an assistance from the organizer, maybe you can share my slides. Right, so I guess that, okay, I'll try again. Apologies for the inconvenience. So my talk again is about this issue of marine environmental protection and how the International Tribunal for the Law of the Sea has played its role in implementing the relevant provisions under the Law of the Sea Convention. So I will start with the some introduction about the state of the marine environment and why is it one of the important matters for the settlement of disputes, and some fundamental provisions under the Law of the Sea Convention that are relevant to not only to the dispute settlement, but also the protection of the marine environment itself, and some ITLOS jurisprudence, which have been discussed earlier, but this time I will focus on the elements of marine environment and some observation as well as conclusion with respect to the current development. So first, I would like to start with these pictures depicting the state of our marine environment. So when we talk about the protection and preservation of the marine environment under the Law of the Sea Convention, most of us in the beginning will think, well, most people think that the environment, marine environment, only deals with the issue of marine pollution. But in fact, actually, the issue of marine environment has developed, increasingly developed within the last decades. We have now also issues of the IUU fishing, for instance, and then as you can see, we also in the picture we also have these phenomena of coral bleaching due to the ocean acidification, and also the marine debris or marine plastics. So the question is, how can we utilize actually the dispute settlement mechanism under the law of the Sea Convention to uphold or to implement the provisions on the marine environment dealing with the issues of our common concern, which is the marine environment. So if we can see that under the law of this convention, we can see clearly under the preamble that it is expected as a legal order for the seas and oceans, which will promote the study, protection, and preservation of the marine environment. But actually, under the law of this convention, the issue of marine environment is not only regulated in one single chapter, which is part 12, but also we find it in other parts of the law of the Sea Convention, for instance, in regard to state sovereignty and sovereign rights, and also, of course, the peace settlement of disputes. So if you look at the provisions regarding state sovereignty and sovereign rights, we can see that under these provisions that not only we can observe the affirmation of state sovereignty and sovereign rights over its waters. For instance, in the territorial sea, we also have these laws and regulations relating to passage that is directly related to the protection of the environment. For instance, under Articles 21, 42, and 54. And also under the rights, jurisdiction, and duties in the EEZ, we also have the jurisdiction of the coastal for the protection and preservation of the marine environment. The element of marine environment also is linked to the conduct of marine scientific research, for instance, the Article 240, and also related to the conservation of marine living resources under the part of high seas, for instance, and also of part 5 on the exclusive economy zone. Now, the heart of the provision on the marine environment is, of course, under Part 12. We have here some fundamental principles with respect to the protection of the environment, which have been acknowledged elsewhere, not only in the field of the law of the sea, but also in the field of international law in general. We have the principle of sovereign rights and no harm principle, for instance, and as the implementation of these rights, states have to take measures to prevent, reduce, and control pollution from all sources, including from activities beyond national jurisdiction, such as in the area. There are also provisions on enforcement, responsibility, and liability, and also the reaffirmation of the importance of global and regional cooperation in tackling issues with respect to the marine environment. Now, our focus for today's webinar is the settlement of disputes, and it has been elaborated in length by the previous speakers as to what constitutes this part. We have the affirmation of the peaceful means of settlement, and then we have the explanation about the compulsory procedures and also choice of procedures, as well as limitations, exceptions. I would like perhaps to add a little bit on the specific arrangements with respect to the marine environment. So for instance, here under Article 290, paragraph 1, that the courts or tribunals under part 15 actually could also issue professional measures or as a part of professional measures to prevent serious harm to the marine environment. And also the compulsory procedure under the law of the Sea Convention will be applied when it is alleged that the coastal state has acted in contravention of specified international rules and standards for the protection and preservation of the marine environment according to Article 297, paragraph 1C. There are also provisions with respect to the establishment of special chambers. We can find it under Annex 6, Article 15. For instance, we have this chamber for fisheries disputes and chamber for marine environment disputes. And also spatial arbitration under Annex 8. It can deal with issues that are closely related to the marine environment, such as fisheries, and also the protection and preservation of the marine environment itself, marine scientific research, navigation, including pollution from vessels and by dumping. Now, I would like to move on to the relevant jurisprudence under the International Tribunal for the Law of the Sea that deals with the protection and preservation of the marine environment. For instance, we have this case of southern bluefin tuna, cases number 3 and 4 in 1999 between Australia, New Zealand, and Japan. So the dispute arose from the adoption of the Convention for the Conservation of Southern Bluefin Tuna, which was agreed by Australia, New Zealand, and Japan in 1993. And there was this disagreement over quota establishment and Japan's program, which is called Experimental Fishery Program. So Australia and New Zealand had concerns that Japan's program actually was in contrary to the Convention for the Conservation of Southern Bluefin Tuna. The case actually was settled in also the arbitral tribunal, but as regard to its loss, it ordered these provisional measures for the parties involved, which stipulated that parties shall ensure that no action is taken which might aggravate the disputes and prejudice decision on the merits, and parties shall ensure that the annual catches do not exceed the annual allocations and refrain from conducting the experimental fishery program. And parties also should resume negotiations to reach agreement on conservation and management measures, including with other states and fishing entities. The second case was the MOX plant case, case number 10 in 2001 between Ireland versus United Kingdom. It concerns with the establishment of a MOX plant at Sellafield, which is adjacent to the Irish Sea. And the government of Ireland had some concerns over adverse impacts on the marine environment and human health from the activities of the plant, especially from the adverse impacts that might be resulting from the mixed oxide fuel used in the plant. And again, here it lost ordered professional measures for both parties that they shall cooperate and enter into consultations on exchange further information on consequences for the IRC arising from the commissioning of the MOX plant, monitor risk or effects of the MOX plant, and take measures to prevent pollution of the marine environment. The third case is the land reclamation, or case number 12 in 2003. It's between Malaysia and Singapore, and it concerns with land reclamation by Singapore, projects undertaken by Singapore in and around the Straits of Johor. The government of Malaysia had some concerns on the environmental impact of the reclamation, and the tribunal ordered these professional measures for both parties that they shall cooperate and enter into consultation to establish a group of experts to study adverse effects of land reclamation, exchange information on and assess risk of land reclamation, agree on temporary necessary measures, and most importantly that Singapore was required not to conduct reclamation projects that might cause irreparable prejudice to the rights of Malaysia or serious harm to the marine environment. Now, apart from the three cases, the International Tribunal Law of the Sea has also adopted advisory opinions that have some contributions on the protection and preservation of the marine environment. The first one was advisory opinion on deep seabed mining, case in 2011, and it was submitted by Nauru and Tonga. So basically, these governments they were asking the tribunal to determine the legal responsibilities and obligations of state parties under the Law of the Sea Convention with respect to the sponsorship of activities in the area. So the response of the tribunal in advisory opinion, actually here we can see it confirms some fundamental principles already acknowledged and recognized under the international law and also the law of the sea, such as due diligence, precautionary approach, and best environmental practices, as well as recognizing that the measures taken by the sponsoring state cannot be less stringent than those adopted by the authority or less effective than international rules. The second advisory opinion was adopted in 2015. It is with respect to the questions from the Sub-Regional Fisheries Commission, especially with respect to the obligations of the flag state in the case of IUU fishing. We'll just get quickly, due to time constraint, to the there are four actually opinions in general from the International Tribunal as regards to the flag state obligations, liability of flag states, and liability of international organizations, as well as coastal states' rights and obligations. Basically, under this advisory opinion, the tribunal recognized the diligence obligation again that the flag state should ensure that the vessels are not involved in the IUU fishing. And then it also highlighted the obligation to cooperate and highlighted the importance of best scientific evidence available with respect to the conservation and management measures, especially the marine living resources. So what we can draw on this jurisprudence is that the International Tribunal for the Law of the Sea has so far helped to reaffirm these fundamental principles of marine environmental protection. It also has provided further clarification of the Law of the Sea provisions for states and to comply with relevant international rules and standards. And also in the the orders and also the opinions in the previous cases, the tribunal here has covered issues relating to the conservation and sustainable use of marine resources as a part of the measures for the protection and the preservation of the marine environment. So it means that the tribunal has helped to expand the scope of the part 12, I'm sorry, not only to deal with to treat the marine environment problems as only concerns marine pollution, but also the conservation and sustainable use of marine resources. So the challenges that we still have in ensuring the role of ITLOS is the jurisdictional issues. It has been elaborated by Professor Dapo Akande and also pointed slightly by Dr. Ramos, that we have some constraints in establishing the jurisdiction, especially we have the arbitration by default under Part 15 of the Law of the Sea Convention. So most of the merits of the case, they are not yet as far as the marine environment is concerned, they are not settled in ITLOS, but other forums or fora such as arbitration, the Chagos arbitration, South China Sea arbitration, and also the MOX plan, as well as the southern bluefin tuna were also settled under the arbitral tribunal. And also the Law of the Sea Convention has a rather different structure of agreement compared to other multilateral environmental agreements. And to some extent, it will also have some impacts on the dispute settlement procedures. But the good side of the prospect of ITLOS is that it can continue strengthening fundamental principles of international environmental law, and it was also reflected not only in the provisional measures but also in the advisory opinions. And under the ITLOS, there is also a special chamber which is specialized in seabed disputes. So in the future, when the exploitation of deep sea mining has come into realization, the disputes will the seabed disputes chamber may also come into play in settling the possible disputes between parties. And there's also possibility to entertain multifaceted cases, as we now have this increasing dependency on marine environmental issues such as climate change, biological diversity beyond national jurisdiction, and marine plastics. And it is also a possibility where the Tribunal for the Law of the Sea, International Tribunal of the Law of the Sea, can play its role. So to conclude, I would like to share my thoughts that ITLOS has reaffirmed fundamental principles of international environmental law, and this is the most significant contribution of this tribunal. So these principles, such as precautionary principle, due diligence, the obligation to conduct environmental impact assessment, cooperation in dealing with marine environmental issues, and underlining the obligations and liability of states with respect to marine environment is a part of what ITLOS has adopted in the provisional measures and also advisory opinion. However, as the previous speakers also have discussed earlier, it cannot be isolated from the nature of law of the sea convention as a package deal instrument. We have to admit that there might be still hindrances in settling the merits of the dispute, especially with in the case of the marine environment. And this is one of the challenges remain, in addition to ensuring ITLOS as an attractive and convenient forum for parties to settle their disputes. As Dr. Damos has already alluded to us about, for instance, the attitude of ASEAN and also Indonesia in particular, we are still rather prefer the negotiation instead of settling through the third-party mechanism. It is also maybe one of the challenge that perhaps we need to take into account in ensuring whether states are willing to bring their cases before the International Tribunal for the Law of the Sea. I conclude with that. Thank you very much for your kind attention. Wassalamualaikum warahmatullahi wabarakatuh.
Well, thank you, Dr. Guzman, for your presentation. It's interesting to see the issue of marine environmental protection discussed in the context of international law, and also your angle around climate change. Of course, climate change affects a lot of small island nations, and of course they could be using this sort of mechanism for disputes around climate change in the future as well. And as you mentioned, also some of them are already doing this. So that's a really interesting subject that I hadn't really thought about. But I hope we're going to get lots of questions now from our participants. I think I can see already that we've got 5 questions. So once again, thank you so much, Dr. Guzman, for that. And we'll now move to the questions. Hopefully we've got lots of questions for each one of you. I'll just get the questions up here. So we've got one straight away from Daniel Rene Kandu, a law student from Universitas Diponegoro, Semarang, Indonesia. His question is addressed to Professor Dapo Akande. Question is, what are the implications of the UK to the Chagos advisory opinion delivered by the ICJ in 2019, noting that the ICJ described the UK's administration of the Chagos Islands as an unlawful act of continuing character, and that the decolonization of Mauritius was not lawfully completed? Is there a possibility that the UK will comply with the opinion and perhaps refrain from the islands? States in the International Court of Justice have made declarations accepting the jurisdiction of the court. In particular, such declarations also include specific reservations to the declaration, military activities and domestic jurisdiction. Would self-judging reservations made by states render the court to lack jurisdiction to adjudicate? An easy question for you, Professor, to start off with.
Well, thank you very much, Daniel. So let me start with your first question, the Chagos advisory opinion. As it happened, actually, I was counsel for one of the states, not the UK, I hasten to add, in that advisory opinion. So you're right that the ICJ held that the decolonization of Mauritius is not lawfully complete. And the effect of that advisory opinion is that the UK has an obligation, well, according to the ICJ, the UK has an obligation to complete that decolonization of Mauritius. And according to the ICJ, the UK has an obligation to hand the Chagos Islands back to Mauritius. Now, of course, this has been quite a contentious issue. It's an advisory opinion, and that's, well, the position of the UK is that it's an advisory opinion, and therefore the judgment, or rather the opinion of the court, is not a judgment and therefore not binding on the UK. That's the position of the UK government there. Whereas Mauritius's position is that though it's an advisory opinion, it is stating what international law is, and that that international law obligation falls on the UK. So far, the UK hasn't shown any indication that it is going to comply with that opinion immediately. The UK has said that it will hand back Mauritius to, sorry, it will hand back the Chagos Islands to Mauritius at some point. But I think, you know, I think it's just fair to say that the ICJ's position is a statement of what the principal judicial organ of the United Nations considers to be the position under international law. Even if the opinion is not binding, it's still a statement of what international law says. The UN General Assembly then adopted a resolution sort of trying to put some pressure on the UK to comply. And it remains to be seen what the UK will do in response to that General Assembly resolution. Now, on your second question, so the second question is about acceptance of jurisdiction of the ICJ. And when states accept the jurisdiction of the ICJ, they can make reservations. Occasionally, they put in reservations that exclude matters within their domestic jurisdiction. This is where your question is relevant. So they say we accept the jurisdiction of the ICJ, but not in relation to matters within our domestic jurisdiction. That's actually not controversial at all. What is controversial is when they then say that we, the state, will decide what is in our domestic jurisdiction. So that's the self-judging part, which becomes controversial. Actually, the court has been faced with a couple of cases where this issue has arisen. And the view that has been taken by a number of judges of the ICJ is that those self-judging reservations are invalid. And they are invalid because essentially they leave it in the hands of the state to decide whether or not the court has jurisdiction. And the court says, or at least some judges of the court have said that it is within the court's exclusive competence to decide whether it has jurisdiction or not. So the effect of those self-judging reservations is that they are invalid. However, that is not to say then that automatically the court will have jurisdiction, because the question that then arises is, if the reservation is invalid, does the acceptance of the court's jurisdiction also become invalid? And here you have a significant dispute between some judges and academics. Some take the view that if you erase or remove the reservation, you also actually have to invalidate the declaration. And if you do that, then the court will lack jurisdiction. Whereas some have held that you can remove the reservation whilst keeping the declaration intact. So it's not a straightforward issue.
Thank you very much, Professor. I hope, Daniel, that answers your question. We now have a question for Dr. Damos. My name is Renata. I am an undergraduate law student. I would like to ask about piracy at the sea. According to IMB report, the seas in Indonesia are the most vulnerable areas for piracy in the world, especially Straits of Malacca and Singapore. In international law, there is a principle of duty to cooperate. This principle is stated in Article 100, UNCLOS 1982, where countries are obliged to cooperate in combating piracy at sea. The principle of duty to cooperate is also stated in the Regional Cooperation Agreement on combating piracy and armed robbery against ships in Asia and the SUA Convention. In fact, Damos, I'm not 100% sure what the question is, but obviously raises a point there. Oh, hang on, she carries on. However, Indonesia has not ratified a RECAP and SUA Convention. RECAP state parties have the right to enter the territorial areas of participating countries to patrol and carry out information sharing systems related to piracy that occurs at the sea. Indonesia does not want recap state parties to enter Indonesian territorial sea by protecting the principle of duty to cooperate. On the other hand, even though Indonesia has been cooperating with neighboring countries, namely patrolling, Indonesia does not share information regarding piracy that occurs in Indonesia's territorial seas, Malacca and Singapore Straits. Has Indonesia violated the principle of duty to cooperate by not sharing information regarding piracy? Up to you, Dr. Damos.
Okay, thank you, Mr. Spicer. This is a very good question. First of all, I would like to explain about the terminology or the term used by the either IMB and also recap. What they do means by piracy. Piracy always take place in the high seas, not in the territorial sea. But the problem is IMB and recap try to put it together. So when it take place in the territorial sea, in the internal waters, in the port, or even in the nearby, in the coast, they always call it piracy. So piracy become a sweeping term to all criminal that happen in the sea. And it is not the case under UNCLOS, because UNCLOS already make it clear that piracy only take place in the high seas, and consequently it will impact about the right and obligations by state. So for example, in the Strait of Malacca and Strait of Singapore, it is not high seas. It is belong to the territorial sea of either Singapore, Malaysia, and Indonesia. So if people say that is the piracy, and it become legally wrong in term under UNCLOS, and it will misleading with a view to the right and obligations of the coastal state. So for example, Indonesia is not under obligations to share the information on what happened in its territorial sea, because it is not high seas, it is not piracy in terms of UNCLOS. So that's one point that I need to emphasize. And then on the second part of the question is about the recap. Indonesia does not participate in recap. Recap is an information center. It's only information sharing center. Indonesia is more focused on the wide waters that Indonesia has. So Indonesia is more concentrated on how to handle the armed robbery in its territorial water and in the archipelagic waters. So of course we are not object to the work of the recap of the center, but Indonesia, I mean, whatever the incident will be reported, it always in the Indonesian waters. I mean, because Indonesia is the most most sea that being covered by recap belong to Indonesia. So that means it is Indonesia's responsibility to handle the incident in Indonesian water. But however, of course, Indonesia like to cooperate with recap on this issue, right? So again, Indonesia non-participation in recap shall not necessarily violation of Article 100 of UNCLOS, because it's totally a different regime. Indonesia responsible to its own waters rather than it is not the responsibility of other states in dealing or in addressing the incident in Indonesian waters. That's, Mr. Spicer, my answer.
Thank you very much. I'm sure that has answered Renata's question. Renata, if you feel it hasn't answered, please send a further one. But we're now moving on to another question from Joko Siswanto. And this question is for Professor Akande and Dr. Damos. Let me just get that up again. It seems to have disappeared. Here we go. John, where's it gone? Seem to have lost the question. It was about the code of conduct and the South China Sea, but I can't see it now.
I think the question was.
We can remember the questions, Mr. Spicer.
Exactly. Yeah. I think the question was whether the 9 dash line, whether Dr. Damos and I think that the 9 dash line of China in the South China Seas, whether we think that it has legal validity. I think that was the question. I don't know if Dr. Damos wants to go first.
I think Professor Akande first.
So, a number of us have already made reference to the decision of the arbitral tribunal in the South China Seas arbitration. So this was the arbitration that was brought by the Philippines against China. And in that case, actually, the decision of the arbitral tribunal tells us something about what the view that the tribunal took of the 9 dash line. I mean, essentially, the tribunal's position was that it had no legal validity because the tribunal took the view that China did not have historic rights in the South China Seas. And the tribunal also took the view that the maritime features in question there were not islands that were capable of generating a maritime entitlement. So I think these are the ways under the convention, these would have been the only ways in which China could have conceivably argued that it was entitled to this maritime entitlement. So having rejected these possibilities, it's then clear that the 9 dash line does not have legal validity in the view of the tribunal.
Excellent. Would you like to follow up, Dr. Damos?
Right, thank you very much. I think I share with Professor Akande. It is very clear, and Indonesian position is also very clear on this. It's already make it publicly, not only through a diplomatic note, but also publicly in the public statement of the foreign minister that 9 dash line has no legal basis under international law, and we reject the claim, and consequently, we have no overlapping claim between Indonesia and China, and thus it means we have nothing to negotiate because we have no case at all. But the most interesting point about this question is I don't remember the name, Mr. Joko. Mr. Joko tried to make comparisons between 9 dash line and Deklarasi Juanda. This is a very good question, and this is very interesting. Of course, Indonesia, quote unquote, breaking international law and making it. So what happened with 9 dash line? 9 dash line to me is still a political declaration. It is political declarations without having legal weight, because nobody tried to translate 9 dash line into legal text or the language of international law as what Professor Mokhtar Kusuma Atmaja did, and there is no even move to bring the proposal into the UNCLOS conference. I mean, it should be negotiated under the UNCLOS mechanism, rather than to put it unilateral act. But the curious questions that I like also Professor Akande to address this issue, what happened if, for example, state try to develop this kind of embryonic political declaration into what so-called customary international law? because this is also effort being made by China, try to say, oh, of course, UNCLOS doesn't cover anything, doesn't cover all things. There's still room for customary international law, and 9-line perhaps could be developed into this kind of customary international law. If Mr. Spicer allow me to put it as my question to Professor Akande, because this is a very important moment to me to have the prominent scholar opinion in this particular case. Thank you, Mr. Spicer.
Excellent. Thank you so much.
Thank you.
Right, I think we've actually run out of questions there, and in fact we have gone over time as well. I think we were due to finish at 17:30, and now we're past that, 17:40 in fact. So, but I'd like, you know, the questions are the most important, one of the most important aspects of it. I just want to see if there's any further questions, or perhaps if any of the speakers or anybody else would like questions directly to each other, just on any of the issues that people raise, please feel free. Otherwise, we could be calling a day. But Professor Akande, would you like to say something?
Question from Dr. Damos.
Yeah.
Yeah. So Dr. Damos asked about whether the 9-line can be translated into customary international law. So the first thing that I would say is that I agree with him wholeheartedly when he says that this is not similar actually or comparable to the development of archipelagic waters in the way that Indonesia did it back in 1957 and then translated into the Law of the Sea Convention. What's the difference? Okay, so in addition to the points that Dr. Damas made, the main difference also is the fact that that concept, when it was translated into international law, became one of general application. So it's not a concept that is special now to Indonesia. Indonesia was the first, but any state actually that meets those criteria is entitled to make use of that concept. This is not true of the 9-line. It's a very specific and very special concept applying just to one state. So it's very difficult to think about a legal rule that applies just to one state. You know, rules of law are of general application. So that's one problem. The second problem, and Dr. Damas asked a really good question about the relationship between customary international law and the convention. Now, of course, it is, you know, it's possible that in an area of law, you have both custom and treaty existing side by side. We're very comfortable with that. That happens in many situations. But what becomes problematic is when it is argued that the rule of custom supersedes the treaty rule. So normally when we have a rule of custom and a treaty rule existing side by side, what the customary international law rule is doing is that it is filling gaps. It's, you know, covering areas that the treaty doesn't cover, or it is supplying a method of interpretation of the treaty. The difficulty that we would have here is that we have clear treaty rules about the maritime entitlement of states. And then the argument that there are customary rules as well is that those customary rules would be used to supersede or in effect to overturn the treaty. I think that would be very problematic. Now, it's possible for that to happen where the treaty falls into what international lawyers call desuetude. In other words, more or less the treaty is dead, you know, and the parties have failed to rely on the treaty. But we are clearly not in that case in relation to the Convention on the Law of the Sea. There's no chance of an argument of desuetude here. So in that circumstance, I find it very hard to see how a rule of custom can supersede or take precedence over a treaty rule that remains sort of alive and vital. That would be my answer.
Excellent. Dr. Damos, are you happy with that answer?
It's very clear. Thank you very much, Professor Akande. It's very clear.
Wonderful. Have we got any more questions? Oh, it's a question from YouTube to Mr. Guzman. Is there any prospect to use environmental protection cooperation to solve disputes of South China Sea?
Okay, thank you. So that's a very good question. I think it is also one of the perhaps let's talk about aspect of the South China Sea dispute. Actually, in fact, the arbitration, the South China Sea arbitration, put some highlights on the Article 192 on the obligation of states to protect and preserve the marine environment. So it clarifies the concept of what is to protect, which is to the protection from future damage, and to preserve is that the states should ensure the maintenance or improvement of the existing condition of the marine environment. In addition, the arbitration also highlighted the states have to take active measures and prevent degradation of the marine environment. So I think maybe this is one of the aspects of the decision of the tribunal that must be observed further with respect to the South China Sea. We understand that we have also to take into account the validity of the 9-dash line, but on the other hand, we have also the condition of the marine environment in the South China Sea, which is to some extent deteriorating or has been has got some adverse impacts from the reclamation around the area. So I think yes, we can use the consideration of the arbitral tribunal on the South China Sea as respect to the marine environment and use it perhaps as a device for a cooperation between the claimant states in the South China Sea. Thank you.
Thank you, Dr. Guzman. Right, we've got questions flying in now. Okay, so the next one is, greetings, my name is Riri, undergraduate law student at Universitas Padjadjaran. Based on the reports provided by the IMO, there are many unresolved cases regarding the abandonment of seafarers. It is very interesting since the entry into force of 2006 Maritime Labour Convention and its amendments. The problem is many flag states acting as a flag of convenience, which is also state parties to the MLC, are neglecting their duty to repatriate those seafarers into their state of origin. Is there any possibility for state supply seafarers to arise a claim towards any FOC for the fulfillment of seafarers' rights? Who'd like to take that question?
Well, maybe I can try to respond on the flag state responsibility. Well, this is the question that actually needs to be scrutinized further, but as regards the flag state and flag of convenience, I agree that this is one of the unsettled, classic yet unsettled issues under the law of the sea, especially when it comes to enforcement. But what I can see, at least from the advisory opinion on the Sub-Regional Fisheries Commission, it is not dealing with the seafarers, unfortunately, but maybe this can be used as a comparison. It highlights the due diligence of flag states with respect to ensuring that vessels flying its flag not to involve in the IU fishing. So regardless whether you are a flag of convenience or not, I think the advisory opinion can shed some light on reaffirming the responsibility of flag states in ensuring that its vessels comply with international rules and standards. And in this case, with respect to the question on the seafarers.
Thank you very much.
Thank you.
I didn't name check Nine Zahra, who asked you your question about the environmental protection, which we thought was a great question. So I'll just name check her. We've got one final question here, and this is for Professor Akande. It's from Kevin Setiadi from Parahyangan Catholic University. And the question is, as the constitution of the sea, unfortunately, UNCLOS is also a negotiated legal instrument that has ambiguous negotiated terms that had and may cause multiple examples of disputes between states. As a result, often the disputes relied on the interpretation of judicial institutions to provide operational meaning to the flexible terms. However, in the other hand, there are also states which remain to have and may be forced its own understanding of the terms. The question is, in the future, do you foresee that those ambiguous terms of UNCLOS would continually need to be interpreted by judicial institutions, or states' practices would also have some say on the issue? I think I've got that one right. Is that okay, Professor Akande?
That's okay. I actually can't see the question myself in the Q&A, but I think I got the gist of it. And it relates to how UNCLOS is going to continue to be interpreted over the years, particularly with regard to some of the flexible provisions that are in there. So this is also a very good question, but I must say that this is not something which is peculiar to the law of the sea, nor is it even peculiar to international law. You have many treaties and many legal instruments which use terms which are flexible for the reason that the questioner said, they're negotiated instruments, and so parties are able to agree in a general sense on what they want, but of course they're not able to agree on, the specifics of how that will play out in every single instance. But the short answer to the question that is put by the questioner is that yes, judicial decisions and arbitral decisions will continue to be important, but state practice will also continue to be important. Why is that so? If we think about the rules of treaty interpretation in international law under the Vienna Convention on the Law of the Sea, what do you look at? You look at obviously the words, you look at the object and purpose. In the event of ambiguity, you look at the drafting history. But what else do you look at? The Vienna Convention explicitly says you look at the subsequent practice which establishes the agreement of the parties as to the meaning of those terms. So, you look at what states are doing and how states are interpreting these terms. And this is a very common way in which treaties get interpreted, and tribunals will themselves look at state practice in interpreting the terms.
Wonderful. Thank you very much. I think we've run out of time, so I think we're going to have to call it a day there. So thanks everybody for your excellent questions. I hope you'll forgive me for missing some of your questions if there's some still outstanding. So at the end of the webinar, as I said before, this event has been recorded and will be available on YouTube and as a podcast on Spotify. So look out for that. Thank you everyone for watching and taking part, and a special thank you to our wonderful guest speakers, Professor Akande, Dr. Damos, Dr. Guzman, plus the Padjadjaran University and the Ministry of Foreign Affairs of the Republic of Indonesia for helping put this event on. We've really enjoyed working with you all. It's been a fantastic experience for me. I've learned a lot, and I know lots of other people have learned a lot as well. So it's goodbye from me, and I hope you all have a wonderful week, and looking forward to the weekend as well, although it's a bit early for that. So thank you all for taking part. I don't know if the Padjadjaran University wants to say a few words at the end.
Yeah, maybe I can say something on behalf of the faculty. Again, our most sincere thanks, appreciation, and gratitude to the British Embassy and also Ministry of the Foreign Affairs of the Republic of Indonesia, our distinguished keynote speaker, Professor Dapo Akande, and also our dear colleague, Dr. Damos Guzman, and also colleagues from the Ministry of Foreign Affairs. It has been a delightful experience to share this webinar with you, and I hope that we can continue this very good cooperation in the future on other topics. Thank you very much. Stay safe and healthy, everyone. Thank you.
Thank you.
Bye. Thank you very much.
Thank you.
Thank you, Mr. Haddon Spicer, for chairing today's discussion. And we would also like to express our gratitude and appreciation to the keynote speaker, panelists, and once again, Mr. Haddon Spicer. Ladies and gentlemen, it was a productive discussion with a theme on dispute settlement in the law of the sea, challenges and prospects. And on behalf of the host, we would like to extend our ladies and gentlemen, during this webinar, on behalf of the host, it is unavoidable that we made some mistake. Therefore, we would like to apologize for the mistakes that we have made. I am Ratih Mulia. I would like to say thank you once again for attending today's webinar, for attending today's productive discussion. We wish you a great day ahead. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Om Santi Santi Om Namo Buddhaya. Thank you.
Thank you very much. Thank you, Professor Akande.
Thank you.
Mr. Spicer.
Thank you very much.
Thank you very much.
Thank you, Pak Gusman.
Terima kasih, Pak Dir, Kak Dian.